Congratulations, beta.
Thank you, ma'am.
Team B2.
Thank you, ma'am.
हाँ दोनों को ऐड करो सर. Team B1, please turn on your cameras. Congratulations, beta.
Thank you, ma'am.
One second only. Beta, now you are selected for the quarter-final rounds, and you know the rules and regulations. Tell me, B1 team.
Ma'am, kindly repeat the rules and regulations.
Rules and regulations. Just wait a second. You are team B1,
One.
and you both are from B2, right?
Yes, ma'am.
Just wait a second.
I just submitted one.
Now actually draw floors. In front of the judges, I will give you two numbers. You have to choose only one. Or we will, if the judge permit us, so judges will decide who will go from the prosecution side and who will go from the defense side. Got it? So now you have to present your case. Just one second. In quarter final rounds, but each team will get 20 minutes to present their case and 5 minutes for rebuttal and show rebuttal. As you know, in the prelims round, judges have the discretion to ask the questions. So, time limit is this, but it is up to the discretion of the judges whether they want to extend the time or not. Got it? And you have well versed experience in the preliminary round. Got it?
Yes.
So, team one, you have not other speaker. Where is your other speaker?
Ma'am, maybe he has joined already.
Where is?
Let
Sir,
me
any
ask.
other person have joined? Yeah, please tell to your other speaker that you have to join.
Sure, ma'am.
Our judges are joining within a minute. गुड आफ्टरनून मैम।
गुड आफ्टरनून मैम।
मैम अब 20 मिनट्स ईच टीम को मिलेंगी। हमें अपना ड्रॉ फ्लोर से चूज करना है कि कौन सी टीम जो है प्रोसिक्यूशन के लिए बोलेगी और कौन सी टीम डिफेंस के लिए बोलेगी। तो
हाँ
हमने
मैम।
1 और 2 नंबर डिसाइड कर रखा है।
हाँ जी।
आप ही चूज करके बता देना 1 नंबर फॉर B1 या 2 नंबर फॉर B2।
हाँ जी। अच्छा, मुझे ही करना है ये?
हाँ हाँ, आप ही कर देना सो दैट ये ना हो ना कि पार्शलिटी वाला सीन तो नहीं है।
नहीं नहीं, पार्शियलिटी तो मैम वैसे भी नहीं है, ऐसी कोई बात नहीं है।
हाँ जी।
तो मैम, shall I
हाँ जी हाँ
proceed?
जी।
So 1 for 1 and 2 for 2, I think B1 and B2 होंगे। You guys are B1 and B2?
We have two teams, ma'am, B1 and
हाँ
B2. Uh,
हाँ।
B2 team, they have two partners, two speakers, two motors. And B1, beta, have you not called your other partners?
Ma'am, he is facing some technical issues in department.
Okay, so you are here. Na? So,
Yes,
ma'am,
ma'am.
till the time sir will join, you please tell for B1 or B2. For B1, which number are you giving? 1 number or 2 number?
Uh, the two girls are B2, I think। उनको फर्स्ट नंबर दे देते हैं, तब तक इनका टेक्निकल ग्लिच भी ठीक हो जाएगी B1 की।
हाँ, ठीक है मैम। So we have decided B1 as a prosecution. So B1, you have to present your case on the behalf of prosecution.
हम्म।
And other B2 team, you have to present the case on the behalf of defense.
हम्म।
Got it? So team B2, it is B1 and B2 team versus B1 versus B2. Sir also has joined. Sir, we have 20 minutes for each team. B1
Okay.
is presenting the case on the behalf of prosecution and B2 is presenting the case on the behalf of defense.
B1
So this is,
prosecution.
yes, sir.
हम्म।
They did the prosecution role only in the initial stage also.
Right. I think they are present from both sides na, in the preliminary round.
No, no, no.
Sir, motor 1, motor 2, both the girls have presented both the sides।
No, 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 no. No.
Sir, it is your discretion. You can change the
You can
part.
change it, sir. Meanwhile, actually, sir, the B1, one of the speaker is again facing some technical problems. So that is why.
So, to my this thing, to my memory and my understanding, the B2 team, in which we can see two girls, they were to give both the versions, but because of the time constraints, they gave only one version, that of appellant.
For the appellant.
Okay, and same goes for B1. B1
Hmm.
gave the submission on behalf of the prosecution
Res-
only, isn't it?
For the no, I think for the respondent, I think.
Respondent.
Respondent, sir. And they
B1
for the
B1
respondent.
gave for the respondent, and
Huh.
B2 gave for the appellant. So
Hmm.
let us do the role reversal. Let us give the role of the appellant to the B1 and respondent to the B2. If my co-judge agrees with me, then it is fine. Otherwise, whatever you decided, that is fine. No issue.
Sir, totally agreed, sir. No issues.
अपना
So
Ma'am,
नेटवर्क
my
what role we
co-speaker
are
has
doing now?
joined.
Huh?
So let's start with respondent first then.
My co-speaker
Because
has joined and he's at the backstage. So I request him to just.
Backstage, somebody may allow him, please. Jyoti, please ask somebody to allow him.
Yeah, please allow.
Okay, so now B1 will be doing the role of appellant. and two will be doing the role of respondent.
Respondent.
So who will start, B1 or B2?
The B1.
So B1 is donning the role of lawyers for the appellant. You may start.
Yes. The counsel is here in the matter of Mr. Vicky versus State of Andhra Pradesh, appearing on the behalf of the appellant. May I address the bench as lordships?
That is your choice. Go ahead. Lordship, sir, madam, or bench, whichever way you like.
The appellant approached the Honorable Supreme Court under the Article 134 of the Constitution of the India. With due permission of the Lordship, the Council would like to reach Lordship with the brief facts of the
134.
case.
You are approaching us.
134. Yes, sir.
134.
Yes, sir.
134 क्या है भाई? What is 134?
The criminal appellate jurisdiction of the Honorable Supreme Court.
Under 134.
Yes, sir.
Okay. पक्का sure?
Yes, sir.
Okay, proceed.
So the brief, with the permission of the Lordship, the Council would like to reach the Lordship with the brief facts of the case. So
Yes.
may I proceed with the facts? Much obliged, Your Lordship. Lordship, from the 14th of January, Miss Eliza, who is the 19-year-old girl, has received explicit and malicious images on her social media platform, Hacker, and the FIR was registered on the same date at the police station of Mani. During the investigation, police, without the knowledge of Mr. Vicky, who is a 17-year-old boy, extracted data and found that the photos were deepfake created through AI technology and traced the IP address of the device which belongs to Mr. Vicky. During interrogation, Mr. Vicky states that his account was compromised and same was found by the tech expert, witness number 3, the investigation during the investigation by tech expert Vinny. Mr. Sharma, who is the inspector of this particular case, compiles the evidences and statements, submits file to the prosecutor, emphasizing the need of thorough examination of privacy breach and hacking aspect of the case. The subordinate court and as well as the Honorable High Court convicted Mr. Vicky under the several sections of the IPC and IT Act and sentenced a 10-year imprisonment. If the council seeks permission from the lordships to start the arguments.
Please.
Please go ahead.
My lordship, the first issue, whether Mr. Vicky can be held liable for the cyberbullying and harassment endured by the Lisa. My lordship, firstly, I submit that during the investigation, the reasonable doubt has been created on the investigation conducted by the police officer. The reasonable doubt, the judgment, the verdict passed by the Honorable High Court is based on the presumption that the act is being done by the appellant. But my lordship, there is no direct evidence which supports the liability against the accused. My lordship, for the purpose of proving the liability of the
Liability against the accused?
sorry, my lordship, appellant.
Appellant.
My lordship, there is no clear-cut direct evidence.
What did you mean by this liability against the accused? What do you want to say by this statement?
My lord, sorry, my lordship, liability on the appellant. There is no valid ground
There is no valid ground for what?
for imposing the sentence, and there is no any evidence which proves that the appellant is the liable for such an offences.
Okay.
Yes. My lordship,
Put your point objectively and in clear manner. Don't create ambiguity by your submissions.
My Lordship, the prosecution has failed to prove the intention of the case. While dealing with I would support this with the case of the Basdev versus State of Pepsu, where the Honorable Court has said that motive is something which prompts the man to form an intention, and knowledge is awareness of the consequences of the act. In this particular act, then neither the prosecution has proved the intention of the appellant, or the investigation which was conducted by the inspector again makes a reasonable doubt in the mind of the court. My Lordship, the
But the
investigation
witness
conducted.
of one of the friends, Sanya, clearly mentioned in her statement that there was a possible motive.
My
When
Lord,
she made the statement to the inspector, Sanya mentions a heated argument between Eliza and Vicky 6 months ago, suggesting a possible motive. It is on
uh,
record, and it has been taken on. It is the statement which has been taken on record while during the investigation by the inspector, by the IU.
my Lordship, the statement of the witness is based on the presumption. It is not any direct evidence that she directly proves that there is a motive. So it is the based on the presumption, and presumption can't be considered as a valid ground in terms of law.
No, but the witness is mentioning about an instance that there was heated argument. That is a fact.
Hmm.
That is not the presumption.
But my lords, after that
And
they
the
have
facts
sort.
clearly shows this that Aliza and Vicky were maintaining a cordial relationship with each other.
My lordship, after the
After the arguments or after any kind of a disagreement between them, the Vicky may raise to this level of taking revenge.
my lordship, actually there is a particular span of 6 months, which is enough for anyone to forget about something which has been done before the 6 months. My lordship,
So
we cannot say.
why your this submission should not be treated as presumption? How do you
Hmm.
conclusively say that Vicky has forgotten everything?
My lordship, there is one case. I'll just figure it
And
out.
it has been proved by the doctor as well that Vicky is a short-tempered person. So how the court raised this presumption that within 6 months of time he did not think to take any to do anything which harassed the woman. A person
My
of a
lord,
short टेम्पर पर्सन अगर किसी को गुस्सा आ ही गया और ऑन द सेम हैंड वो ये भी कहते कि वो काम था तो मे बी प्रेजेंट सिचुएशन में काम हो गया और 6 महीने में उसने अपना गुस्सा का बदला लिया.
My lordship, it was the Mr. Vicky who has blocked her on her social media account. And even it is a well settled law that the circumstances from which conclusion of guilt is drawn should be fully proved, and such circumstances must be conclusive in nature. Moreover, all the circumstances
Vicky
should be.
blocked Aliza.
Yes, my lordship.
Still, the still the malicious messages were sent from Vicky's account to Alicia's account, Alicia's account. Though she
My
was
lordship.
blocked by. Can you
My
please clear
lordship.
this concept of block and unblock? How does it
Uh,
relevant in the IP Act?
my lordship, after the heated arguments, when they went to the psychologist, so they have taken the sorted out their matter. After which, Miss Eliza said that she doesn't want to take any conversation with Mr. Vicky. So Mr. Vicky has blocked her on the social media platform. After that, the Vicky has also stated that his accounts were compromised. Even I will cite the case law that the verdict of Superior Court of Pennsylvania made it clear that the trial court needed to request expert testimony from the Commonwealth regarding IP address tracing. This ruling emphasized the difficulty of determining geographical location from IP address and the amplitude of lay witness testifying to such highly technical matters during trial, because they are not qualified to make any definite statement on such matter. My lordship, in accordance with this particular judgment, although the IP address of the appellant was had, but no one knows that who was present at the keyboard. We can't have, based on the presumption, we can't take that it was the wiki who has committed because it is a virtual offenses and it is in front, it isn't the front of any person. So we can't presume that he is the liable person.
When the accused came to know that his system is compromised,
My lordship, he has mentioned on the during the interrogation, but nothing is mentioned in the facts are silent about this.
okay. So whether he has made any police complaint or he has taken legal recourse for this issue?
No, my lordship.
No. Okay,
Did he
continue.
take any opinion? Did he take any opinion from the IT expert? That
Ma'am,
how did he come to know that his account was hacked?
my lordship, the statement of the IT expert Vinny states that the accounts of the Mr. Vicky was compromised during that period. So that is enough to make a presumption for a prosecution. And the court handling the criminal, I would like to cite one of the case. It's the Ramesh Harijan versus State of UP, where the Honorable Court states that the court handling criminal cases should consistently bear in mind the considerable mental gap between may be true and must be true. The fundamental and crucial principle serves to uphold the crucial distinction between mere conjectures and definitive conclusive, necessitating a dispassionate judicial examination grounded in thorough and comprehensive understanding of all aspects of the case, including the quality and credibility of the presented evidence. My lordship, the essential element which is for the 509 of IPC is the intention, but the prosecution has failed to prove the intention of the case. And my lordship, at the end, the report of the report of the police officer creates a reasonable doubt because he emphasized on evaluating the privacy breach as well as who was the real perpetrator is still missing from the investigation report. Uh, it is therefore submitted before the Honorable Court that the appellant is not guilty for offences of cyberbullying and harassment. The appellant did not have any guilty intention to do such offence, and investigation is itself creating a reasonable doubt. It is pleaded that the appellant should be acquitted from the present case. If the court may allow, may I proceed with the issue 2?
Yes, yes, please.
My lordship, the issue 2 is whether the age of Mr. Vicky warrants special consideration for him and should he be regarded as a juvenile or an adult in these legal proceedings. My lordship, here the Honorable High Court has considered him as an adult, which is in injustice with the appellant. My lordship, for this, I will cite a case of Ram Prasad Sahu versus, and others versus State of Bihar, where the appellant in the criminal appeal, the court held that the appellant in the criminal appeal shall be acquitted particularly because he was juvenile and had no overt act attributed to him. It further held that the penological goal of converting an offender into a non-offender will be frustrated if young men are involved in and confined in an assumption that brutally will correct. My lordship, I was just like to mention the section 15 of Juvenile Justice Act. My lordship, it cites the preliminary assessment into heinous offences. Firstly, my lordship, the heinous offences are those offences for which the punishment are 7 years or more than 7 years. My lordship, nothing Mr. Waki has committed no offence for which the punishment of more than 7 years can be given to him, which is completely injustice to with him. My lordship,
So
the preliminary assessment.
it means you are trying to submit before the court that he should be punished for less than he should be punished around 7 years. Or
My
you know,
This is
lordship,
what
by mistake he
exactly.
has been given, he has been imprisoned for the term of 10 years.
my lordship, I am just trying to
Once
figure out.
you are defining, once you are submitting the definition of the heinous offences before the honorable court, you draw our attention towards the punishment in the heinous offences. It means you yourself submitting that my client for whom I am praying for acquittal, but I myself submitting that my client is adult. That is why at least 7 years punishment should be given by the honorable court to him.
My lordship,
And it
I
was
am just
mistake on the part of the High Court granted 10 years punishment to him.
my lordship, I am just
See,
trying.
just a minute. I would tell you the point which the ma'am is trying to make.
Hmm.
She is just trying to emphasize that your arguments are inconsistent and lack clarity. Why? Why? Because when you are dealing with issue number one, you say that he is not guilty. When you are dealing with issue number two, whether he is
Yes,
adult or
sir.
juvenile, you are saying that he cannot be given punishment more than 7 years. So it means you are indicating that he can be given punishment up to 7 years.
My lordship, what I was trying to present before the honorable court
No,
that
there is a way to present it. There is a way to
Hmm.
present it. Okay.
my lordship, yes, my lordship.
Sir, in
There
the
is
last proceeding, you taught us the art of a presentation and the art of concealing.
yes.
That point
Yes,
meant to be concealed.
my
No, see, it is very simple. You can simply say, while not admitting that my client is guilty,
Hmm.
yes.
but presuming that if he is guilty also, then also the punishment meted out is excessive and against the law. That is the
Hmm.
argument.
My lordship, the thing I was trying to present before the honorable court is that any child will be considered as an adult only if he has attributed the heinous offences. But in this present case, none of the charges which are marked on the juvenile, on the
Hmm.
appellant, is none of them is a heinous offence. So how the court can treat him as an adult if he has not attributed any of the heinous offences? That's the point I was just trying to
So this
ask.
is what? This is error of fact or error of law?
My lordship, it is an error of law because
How?
the
How?
my lordship, the court has considered the person who has committed none of the offense which is categorized in the heinous offense. The court has considered him as an adult.
Okay, chalo. Point taken.
Uh, yes, my
You may,
lordship. My
you
lordship,
may, if you have concluded on this issue, then you may start the next issue.
Hmm.
Uh, my lordship, I just want to add on one more of the case law that where
Right.
the court has said that all juveniles should not be grouped into single class. Instead, juveniles should be given individual consideration and evaluation on the basis of their particular maturity level and life experience and feelings of moral responsibility, background history. Thus, giving due consideration to the idea of different treatment of juvenile is important. My lordship, the appellant has a good family background. He is from well-reputed family, and he is having a good score. My lordship, at the end, I just respectfully submit before the honorable court that the court exhibit an excessively rigid stance on the juvenility. It has been noted that despite the commission of a grave or a severe offense, juveniles are granted leniency due to their age, being tried as minors, and in certain instances acquitted. Even the uh, even the preamble of the Juvenile Justice Act says that the welfare of a child is important. I just pass over the issue 3 to 8.
I would like to again seek clarification. You want your client's acquittal on the ground that he has not committed offense or on the ground that he is juvenile?
Hmm.
On the ground that my lordship he has not committed any offense.
Then your explanation, your arguments on issue number two are completely rejected. You proceed on next argument.
My co-counsel will continue.
Yes, yes, please. We even try to
Counsel
hint you
for
out how to construe, how to make your arguments. In spite of that, you have unnecessarily stick to that position. Okay, continue on third issue.
Counsel for the appellant seeks permission to address issue number 3 and
Yes,
4.
please continue.
Thank you, Your Lordship. Issue number 3 deals with whether the penalty imposed on Mr. Vicky is justified and legitimate or not.
Yeah.
It is humbly submitted that acts of Mr. Vicky is being accused of should attract the provisions under Juvenile Justice Act 2015, and therefore he should be convicted under the same. That the prolonged detention of the minor appellant in the company of hardened criminals would surely be subversive of that object. And even Mr. Vicky himself was the prey of cyberbullying and impersonation by the hacker, and the court erred in the law by punishing him, and neither was there any conclusive proof to suggest that only Mr. Vicky was guilty of the offense. The criminal punishment should always be enforced
4 minutes
as a
left
last
in 20 minutes. Only 4 minutes
last
left for 20 minutes.
as a last resort and not at the primary punishment in the given case. It has also been said in the case of Lena versus State of Haryana that indeed that there is a requirement of punishment to be disproportionality great, which is corollary of just desert, is dictated by the same principle that does not allow the punishment of the innocent, because any punishment in excess what is deserved for the criminal conduct is punishment without guilt. The idea of criminal prosecution should be subjected to merely attain favorable outcomes. It is humbly submitted that such grave offences, such grave punishments awarded to a juvenile violates the basic criminal principles of sentencing policy along with the objectives of Juvenile Justice Act. Our law society, our law works upon the theory of reformation. By giving the punishment which is very hard in nature and which is of the 10 years will affect the mind of the juvenile, and it is his growing stage where he is put behind the bars, where he won't be able to enjoy the life, he won't be able to continue his the job criteria, and he will face many issues in the upcoming future. Even in the famous case in the judge, I'm sorry, the landmark judgment of Nirbhaya gang rape case, the juvenile who was offended in the rape case, he was also sentenced for the 3-year imprisonment and was later on transferred to a rehabilitation center. It was said by Supreme Court that the juvenile's mind lagged in the maturity, development differences between mind and minor of that child. He should not be tried as an adult. Whereas in this case, merely on the basis of serious offense, which has not been committed by the accused also, the court violated all the tenets of law and passed the exorbitant sentence. The punishment on the appellant is against the provisions of Juvenile Justice Act 2015, therefore it is deemed vitiated. The conviction should have been made with respect of Juvenile Justice Act 2015. At last, I conclude that it is humbly submitted that although the issue is not in the question because the petitioner denies all the charges, levels against him, and the honorable court has erred, and therefore conviction is bad in law. The act was committed, it was not in the kind of heinous offences, and the court could have surpassed the punishment provided in the statute. The court had completely disregarded the doctrine of proportionality and pronounced the sentence, way above its gravity of in which it was committed. And even if that Mr. Vicky had to be convicted, he was supposed to be convicted within the guidelines of Juvenile Justice Act and not solely under the IT Act 2003 and IPC of 1860.
Okay, fine.
If Lordship are good with the issue 3, may I proceed with issue number 4?
Yes, yes, proceed. Quickly proceed to issue number 4.
Issue number 4 talks about whether the wiki's fundamental right of privacy has been breached or not, and whether the investigation should be set aside on the forced ground. It is humbly submitted that privacy is an inherent aspect of an individual's right and exert authority over the personality. This concept stems from the belief that certain rights are innate and integral to human beings. Natural rights, being inseparable from the human personality, are considered inalienable, and the existence of natural rights is indispensable to the human experience. As said in the case of Govind versus State of Madhya Pradesh 1975, right to privacy constitutes an integral component of the rights granted under Article 21 of Indian Constitution. It has also been said in the landmark judgment of Justice K.S. Puttaswamy K that the right of privacy of an individual is not only protected by Constitution under Article 21, but is also an intrinsic part of scheme of Part 3, which guarantees fundamental rights. It is humbly submitted that even provisions of Section 165 of CRPC is enacted to authorize that police to conduct a search in situations of urgency where the protracted process of obtaining search warrant from magistrate is impractical. However, in the present case, the police officer did not face any sort of immediate urgency to request the individual's internet details and enlist the services of technology expert for tracking his activities. As guidelines mentioned under the Digital Personal Data Protection Act of 2023, it says a person may process the personal data of a data principal only in accordance with the provisions of this act and for a lawful purpose, for which the data principal has to give the consent and or for the legitimate use. And in this particular case, no consent was given by Mr. Vicky or by his legal guardians. It was stated in the case of State of Maharashtra versus Bharti Shanti Lal by Supreme Court that certain criteria of procedural validity stipulates that procedures must adhere to principles of fairness, justice, and reasonableness, precluding any arbitrary, fanciful, and abrasive measure. At last, I want to say that uh, it is humbly submitted and
Yeah.
most respectfully submitted that Vicky's right to privacy has been breached in the investigation, and thus the investigation should be set aside. Every person has the fundamental right to privacy against the arbitrary power of the state, and methods that they use for investigation and any process that goes beyond the limit that violates the right to privacy, as happened with Mr. Vicky. It has also been established that investigation thus conducted needs to be fair, reasonable, and in line with the due procedure of law, which was not done in the case of Mr. Vicky. The council seeks for the
Have you
prayer.
summarized? Your arguments are over?
Yes, sir.
Okay. So what are your prayers?
Wherefore, in the light of legal precedents, principles cited, and considering the provisions of statutes applied and arguments advanced, it is humbly pleaded before the Honorable Court that this court adjudges and declare that first, hold Mr. Vicky as juvenile who had no direct involvement with the offence herein and thereby acquit him. Second, hold the impungent order sentence invalid with respect to the Juvenile Justice Act 2015. Third, strike down the imposition of criminal liability on Mr. Vicky and or pass any such orders or issue such directions or grant such relief that it may deem fit in light of justice, equity, and good conscience.
Thank you.
Thank you.
Thank you.
One advice for future moot court competition, that you should have clarity and you should frame an order of precedence of your argument. Which argument should prevail over another argument of yourself only? Okay. And you must also see, when there is an intricate problem like this where two substantive issues are involved, then you should always arrange these issues in a manner that your arguments do not infringe each other. Okay. Thank you.
Thank you, Your Lordship.
Chalo. The other team, B2. You are the respondent. Start your arguments.
Council seeks permission to start with argument. Issue number 1.
Continue.
Issue number 1. Whether Wiki can be held liable for cyberbullying and harassment.
Just a minute. Hold on. Jyoti, they have the right to rebuttal, na? Opposite team.
Yes, sir. Actually, team B1 has taken 26 minutes 32 seconds to present their case.
Okay. So
So it is, yeah.
you count their timing as 23 minutes. You attribute 3 minutes to us, to our questioning.
Okay, sir. No.
So so team B1 to remain in the hearing because you have to do rebuttal also. So team B2 to continue.
Whether Mr. Wiki can be held liable for the cyberbullying and harassment endured by Eliza. We represent state of Andhra Pradesh, the respondent in this case. Mr. Wiki have clear motive and opportunity. Witness testifies establish a strained relationship between Miss Eliza and Mr. Wiki, providing a potential motive for cyberbullying, which is relevant under Section 8 of Indian Evidence Act 1872. Mr. Wiki presence at Howard High strengthened the opportunity to access information about Miss Eliza under Section 7 of Indian Evidence Act
Can
1872.
you explain the motive in your own terms? What motive he had?
He have motive of jealousy, your lordship. Vicky and Eliza, they both have applied for their dream university where Eliza got selected. Whereas they both were good friends at back. But before 6 months, when Eliza got admission, rather than being happy for her, he showed his aggression towards her. He should be happy for her if we conclude that he was a good friend, but he wasn't. Rather than that, he was angry. They both fight, and we have witness to state that they both have a good fight.
Okay, so
Vicky should be happy.
have you gone through the facts in detail? Uh, there is an observation which says that uh, the person, Dr. Anish, who examined both of them, counseled both of them, he said that Mr. Vicky was okay, but Eliza was very bitter about the quarrel.
Your lordship, it was after the fight. But they had a fight, it is defined in the fact. Indeed, they had a fight. Rather than if they were good friends, they should be celebrating. But at initial reaction was his that anger he faced. That is the reason behind their fight, and many of their friends know that they fought 6 months back. Later on, they might have Vicky might have planned or might be sitting quiet because he might be waiting for some chance to express his anger.
So
But
you also believe it that it is might be, means you are also not certain.
no, your lordship, we are sure about this that Vicky have planned this all himself. Vicky is
Okay.
guilty of cyberbullying and harassment. He have the motive.
Okay. Continue.
Cyberbullying and harassment are the serious issues that affect the mental health and emotional well-being of the victims. Cyberbullying can take various forms, such as posting harmful, hurting, derogatory comments, fake information, threats. Cyber harassment can also include stalking, hacking. The devastating impact of cyberbullying. Cyberbullying has become a major issue with the severe consequences for the victims. The anonymity provided by the digital world bullies people, leaving lasting emotional scars on their targets. Miss Eliza, a victim of such a heinous act.
So this is your sentiment, or it is somewhere defined in any law? This you feel that this is this kind of offense, or it is somewhere defined in law?
Or it's just or it is just a oral submission.
This is just an oral submission as far as our
So
knowledge.
Do we
you
need
are
to
not
take?
you,
Sorry, sir.
so you are not arguing on facts and law. You are arguing on your sentiments, what you feel.
No, your lordship,
You
we
are
are arguing
just person is
facts
submitting
and
your sentiments, do we need to
but
take it on
yes,
record?
pardon
I
me, ma'am.
don't think so that your sentiments should be taken on record, ma'am.
Your Lordship, we are arguing on the basis of facts and case laws, but this heinous offense itself isn't defined in law exact meaning what heinous offense is, but the consequences cyberbullying has said there it is defined,
But
and also
which
Juvenile
is the
Justice Act.
closest one? Which is the closest one?
Your Honor, the closest one is defined in section
Which
33 of subsection 33 of section 2 of Juvenile Justice Act, where heinous offences is defined and where the punishment was also defined.
so what that section reads?
That section reads that the heinous offense committed by the juvenile can be punished the offense which have original punishment of more than 7 years. Even juvenile can be treated as an adult and given that punishment under that section.
No, no. The offense. I want to know where these actions have been categorized as an offense. Where the cyberbullying has been categorized as an offense. Where it is defined.
IT Act.
Section.
Section 67 of IT Act. Cyberbullying and harassment are the grave offences under Information Technology Act 2000, Section 67.
Section 67. So they are defined
Yes,
as grave offenses.
yes, Your Lordship. The Supreme Court in Shreya Singhal versus Union of India upheld it constitutionally.
Constitutionality has been upheld. I want to know about the offense. Where these things have been categorized as an offense. You want
Your
conviction.
Lordship, Section 67 of IT Act and
What is
also
the
Section
what is the
6A.
punishment under, what is the punishment under section 67?
Your Lordship, 3 years.
So how you are asking punishment of 10 years? Under which provision?
Your Lordship, we are asking permission under IPC.
So you
Under which
first need to
section?
have the clarity, na, under which provision you want the issue to proceed.
Your Lordship, issue 1 contains cyberbullying as well as harassment. So we are asking punishment under cyberbullying, adding with on harassment because Elisa faced
Punishment for the cyberbullying is 3 years. Punishment for the
yes, Your
heinous
Lordship.
offense is 7 years.
Yes,
These
Your
are
Lordship.
two separate. Yes, these are two separate penal provisions in two separate acts, and you are
Yes.
seeking, you are praying for 10 years of imprisonment.
Your Lordship,
So will you
the issue
please
we are
explain
addressing
under which
right now.
provision, under which provision or under which law you have been praying for the 10 years imprisonment for a child
Your,
who has been treated as an adult throughout the proceedings?
Your Lordship, right now we are giving facts and circumstances for the issue 1, and we'll come back to this issue where we'll justify why Vicky should be imprisonment with the 10
Okay,
years.
okay, continue. Continue. We only want clarity
Hmm.
that under which all section you are praying that this offense has been committed and this offense is covered under these sections.
Your
This
Lordship,
clarity we want from you.
Section 503 of Indian Penal Code also define online harassment,
Okay.
and IT Act also defines this harassment of cyberbullying.
Okay. Anything else?
What is the punishment in the IPC provision?
And also Section 354 of IPC punishment.
Okay. Okay. So which all provisions you want this? Because your material does not reflect any section. You tell me under which all provision you want his conviction.
Your Lordship, we want conviction under Section 66A, 66C, Section 354 of IPC, and Section 503 of IPC.
354, 503
Yes, Your Lordship. 509.
and 509 also.
Yes, Your Lordship.
And 66A and 66 of which act?
IT Act. 2000, Your
66C,
Lordship.
66C.
Yes, Your Lordship. Even 66B also comes must should be used, but it has been abolished, so we cannot use that as our defense. But it clearly defines the section sir is asking where it is defined this cybercrime is a punishment, but as of now it is not valid. 66B.
Hmm.
Okay.
Please continue, ma'am.
Much obliged. Issue number 2. Whether the age of Mr. Vicky warrants special consideration for him and he should be regarded as a juvenile or as an adult in these legal proceedings. While Mr. Vicky's age may suggest a developing mind, the crime he is accused of is a heinous. Cyberbullying is a serious offense which potentially devastates consequences for the victim. The emotional and psychological scars inflicted by such malicious act can be long lasting and have a significant impact on a personal well-being. The maturity of the act, not just the accused. The court must consider the maturity of the act itself, not just the age of perpetrator. Mr. Vicky
Of the
alleged
accused,
action.
you are saying
Uh,
the
Pardon me,
maturity
ma'am.
of the accused.
The maturity of the act.
Hmm.
According to the NCRB, which is National Crime Report Bureau data, the rate at which juveniles are held guilty is much higher than the conviction rate for adults. In 2020, 91.4% of the juvenile accused were held guilty. The Juvenile Justice Act of India has undergone revision to account for the involving nature of the crime, particularly cybercrime. These amendments recognize the increasing capacity of the minor to commit serious offense and emphasize the need of appropriate punishment. Sophistication of the crime. The use of AI generated image suggests a planned and sophisticated cyberbullying attack, not a momentary lapse in a judgment. The level of planning and technical knowledge undermines the argument that Mr. Vicky lacked the maturity. But to understand the consequence, deterrence. The harsher sentence for Mr. Vicky could send a stronger message to other teenagers. Considering cyberbullying, this could serve a deterrent to prevent similar incident in future, especially with increasing prevalence for cyberbullying. Teenagers are often early adopters and proficient users of technology. This familiarity arguably reduces the argument that the lack of knowledge and understanding of the online world includes the potential and pitfall. Additionally, cyberbullying often extends beyond the school hours. In conclusion, for this issue, Mr. Vicky's age should not be shielded for his action. He committed a very serious offense that accused immense emotional distress to Miss Eliza. The evolving nature of cybercrime and the recent amendment of the Juvenile Justice Act necessitate a strong response. Treating Mr. Vicky as an adult to this case upholds justice, protects the vulnerable online, and promotes sense of accountability for the serious cyber offense committed by the minor.
Kindly conclude this.
Issue
Issue
number
2.
3.
Issue number 3.
Whether the penalty imposed on Mr. Vicky is justified and legitimate. The Honorable Supreme Court of India, we represent the state of Andhra Pradesh, the respondent in this case. Severity of the offense. Emotional distress. The cyberbullying caused Ms. Eliza significant emotional distress, potentially leading to depression, anxiety, and even social stigma. A 10-year sentence reflects the seriousness of the harm inflicted. In the landmark case of State versus Drew, it was held a 16-year-old defendant who received a significant sentence of cyberbullying a classmate. The court acknowledged the emotional harm caused and the potential long-term impact on the victim. The use of AI generated images suggests a planned and deliberate act, not a childish prank. This level of premeditation necessitates a harsher punishment to deter similar attempt and reflect the calculated nature of the attack. In the case of State versus Merchant, the Honorable Court stated that imposed a significant sentence, highlighting the planning and technology involved. A strong sentence for Mr. Vicky sends a clear message to other teenagers considering cyberbullying. It demonstrates the potential consequences and discourages future acts promoting a safe online environment. Miss Eliza deserved justice and compensation for the emotional distress she endured. A significant sentence for Mr. Vicky acknowledges the severity of the offense and provides Miss Eliza with a stronger sense of closure and safety. While Mr. Vicky's age is a factor, psychological evaluation could determine his maturity level. If the evaluation indicates a developed sense of responsibility, a 10-year sentence might be appropriate to hold him fully accountable. Even within a 10-year sentence, Mr. Vicky could participate in rehabilitation programs. These programs, the 10-year sentence imposed by a lower court, reflect the severity of the crime. It is not excessively harsh, considering the lasting impact on the victim and the need for deterrence. However, the court has the discretion to consider Mr. Vicky's age during sentencing deliberations. Impact on Miss Eliza's reputation. Explore the potential damages to Miss Eliza's reputation due to the cyberbullying. This could involve lost opportunity, social stigma, or even financial repercussions if the incident affect her future prospects. Introduce expert witnesses specializing in cyberbullying and its psychological impact. Their testimony can bolster the case by establishing the severity of the emotion distress inflicted on Miss Eliza and the potential long-term consequences. Issue number 4. Whether Vicky's fundamental right of privacy has been breached in the investigation as his system was looked into without his permission and knowledge, whether the investigation should be set aside on the aforesaid ground. Cyberbullying is a serious offense with lasting psychological consequences for victims. While warrants are generally preferred, the investigation into Miss Eliza's cyberbullying involved exigent circumstances. A 19-year-old girl was subjected to a malicious attack, causing her emotional distress. There was a need to act swiftly to gather evidence and identify the culprit before further harm could be inflicted. Cybercrime investigations are complex and necessitate specialized techniques. Electronic evidence is often vol- volatile, volatile and can disappear quickly if not promptly secured. Delaying the investigation to obtain a warrant could have resulted in the loss of crucial data. Given the nature of digital evidence, immediate action might be necessary to prevent the deletion or alteration of data. This urgency could justify the inspector decision to search without the consent of the accused. If the, inspe- if the inspector had asked for Mr. Vicky's consent before assessing his laptop, it could be argued that Mr. Vicky's right to privacy was not violated. Consent is a key factor in determining whether a search is lawful or not. The inspector has a legal responsibility to conduct a thorough investigation. This responsibility could justify the search of the laptop even without Mr. Vicky's consent. The inspector could argue that the search was necessary to ensure a fair and thorough investigation. This could outweigh Mr. Vicky's privacy concern. He likely assessed readily available data on Mr. Vicky's device, such as logs and login information, to establish a connection to the cyberbullying incident. It is highly improbable that a full forensic examination of the device was conducted without a warrant. Even if a technical violation of Mr. Vicky's privacy rights occurred, the evidence obtained could still be admissible in court under the inevitable discovery doctrine. This doctrine states that evidence obtained illegally can be admitted if the authorities would have inevitably discovered it through legal means. Conclusion: the investigation did not constitute a flagrant disregard for Mr. Vicky's right to privacy. The investigative method employed were reasonable and proportionate considering the circumstances. Excluding evidence based on a technicality would be detrimental to the pursuit of justice. We urge the Honorable Supreme Court to consider the broader societal impact of cyberbullying and the need for effective investigation to protect vulnerable individuals. While privacy is important, it should not be used as a shield to protect the perpetrator from accountability. We pray before the Honorable Supreme Court to adjudge and declare that Mr. Vicky is liable for the cyberbullying and harassment endured by Eliza, considering the circumstantial evidence, digital forensic, and potential psychological factors. Acknowledge that Mr. Vicky, being a minor of 17 years of age, should be treated as an adult in these legal proceedings, considering the severity of the crime and the need for a strong response to serious cyber offenses committed by minors. Uphold the 10-year sentence imposed on Mr. Vicky as it reflects the seriousness of the crime and the need for deterrence while also considering Mr. Vicky's age. Dismiss Mr. Vicky's claim of a breach of his fundamental right to privacy during the investigation, considering the reasonable and proportionate investigative method employed and the necessity of the investigation, and pass any other order that this honorable court deems fit in the interest of justice, equity, and good conscience, which this honorable court may deem fit in light of justice, equity, and good conscience, all of which is respectfully submitted on behalf of the defendant. Thank you.
Thank you. Thank you.
Thank you. I think rebuttal का टाइम था इनके पास या क्या है एक बार देख लेते हैं.
The counsel for the appellant wants to go for the rebuttal round.
Please proceed ahead. Sir,
You have only 2.5 minutes to summarize your rebuttal. Only 2.5 minutes. Your time starts now.
Your Honor, the Lordship, the prosecution has failed to prove that the conclusive report of the investigation, which was conducted by the Mr. Sharma, it has still mentioned that there is a need to find the real perpetrator, and the prosecution can't take a presumption that who is sitting behind the keyboard and working on the digital hacking and what the offense has been committed. Secondly, the prosecution has declared that the 66A should be applied, but I must humbly submit that it is being declared unconstitutional by the Honorable Supreme Court in one of the cases. My Lordship, while dealing with this section of 509,
this has been mentioned by the council of I think 66A has been declared unconstitutional. That has been mentioned by the council.
My Lordship, the prosecution has said for the 66B, not for the A.
66A.
Yes, my Lordship.
Are you sure 66 has been set aside by the Supreme
Yes,
Court as
sir.
unconstitutional?
Yes, sir. My Lordship, moreover, the section 509 of the IPC, the essentially element of this particular section is the intention which the prosecution fails to prove. The prosecution fails to prove the justify the period of the 6 months gap between the offences. The prosecution has failed that the punishment for such an act falls in the heinous offences. The prosecution can't just say that the 3-year punishment, the offence for which the 3-year punishment is being given, is the heinous offences. My Lordship, the statement of the Dr. Anish, psychologist, is not binding upon the court. Furthermore, the preamble of the Juvenile Justice Act should be considered by this honorable court, where the court has said that the welfare of the child has to be considered before sentencing. While dealing with the Nirbhaya case, the honorable Supreme Court had held that child is not something to being set aside as an example for the society. Child should be taken care by the reformative theory of punishment. That's all.
That's all.
Yes, ma'am.
The second mooter of this team, your arguments are concluded. Okay. Anything else you have to set? B2. B2, you have cited a section which is set, which has already been struck down by the Supreme Court.
Pardon me, Your Honor, I haven't.
So your research was not up to the mark.
Your Lordship, I haven't. Might be some network error. Could you please repeat, Your Lordship?
66A, on which you have relied for punishing the accused, has already been set aside by the Supreme Court.
Yes, Your Lordship, we have already mentioned before that the
No,
exact.
you mentioned 66B, not 66A. The opposite counsel is right in his submission.
Sir, the
Your
counsel for the
Lordship,
response mentioned it. 66A. They mentioned it.
Your Lordship,
One concluding line, yes, one concluding line, B2.
one concluding line, Your Lordship, we want to send here this. We want to say here only this that Vicky should not be only left just because he is a juvenile. A juvenile might be under 18, but the crime he has done, its consequences on Eliza's life, her future, her emotional, we never know what can lead her to nowhere.
Okay,
She will
okay,
remain unconfidential throughout her life.
okay, okay. Thank you. Thank you. Both the teams can be logged out. Thank you for your submission. Good job done. But you are both the mooters, both the teams. You for future, I am advising you. Your research is weak. Okay. And team B2, you have to. You are not to read the text. You are to look into the eyes of the court. Okay. B2, the both these girls,
Yes,
you
sir.
did well. Only thing is you need to, your material is good, you need to improve on your presentation. Okay.
Yes, Your Lordship.
ओके कैरी ऑन ज्योति आप इनको निकाल सकते हैं आप लॉग आउट कर सकते हैं ओके
Yes, sir. Beta, we will intimate you for further things. You can leave the limits.
Thank you.
Thank you, Your Lordship.
हाँ जी सर.
थैंक यू सो मच सर मैम. रिजल्ट हम फोन पे डिस्कस करेंगे.
हाँ
यहाँ
अभी
पे नहीं हो
कॉल
सकता.
मेरी तरफ से
कॉल कर लो अभी
organizing
कॉल
team
कर लो
की
खत्म
तरफ
करते
से.
हैं लेट अस फिनिश दिस ऑफ
हाँ हाँ 1 second.
जस्ट
मैं आपका थैंक यू तो बोल दूं ना. थैंक यू सो मच.
थैंक यू ले लिया हमने थैंक यू ले लिया थैंक यू ले लिया बहुत 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 काम वेट कर रहा है थैंक यू ले लिया बहुत काम वेट कर रहा है
सर मैम का थैंक यू ले रहे, मेरा थैंक यू ले लीजिए.
हाँ हाँ आपका भी थैंक यू आपका बहुत
Sir,
बहुत
thank
थैंक
you so much. I am been honored actually to share the
Same.
dice with you, sir. Thank you so much, sir, for the
same here you are
for your
very
value.
mature person and I am sure you are a good lawyer and definitely since you are in Saket only we'll meet someday.
Sure, sir. Sure, absolutely, sir.
आप एक कर लो कॉल खत्म करते हैं इसको इस काम
I
को
am
खत्म करते हैं
calling you, sir. Yeah, I am calling.
हाँ.